Okay, Mr. Botolio, part 2. Let me pick up where I left off. So I found those certificates. We'll start with the first one, certificate completion. May it be known that this certificate has been presented to Michael Paul by the Fire Corps in FBA, and it's for completion of the Introduction to the Fire Corps program, FC 100. Instructor was Sarah Lee, date February 11th, 2019. Then we have the another Fire Corps certificate. It says, may it be known that this certificate has been presented to Michael Paul for completion of FC 304, conducting home safety checks. Also by Sarah Lee, the director, also February 11th, 2019. And I don't know if I showed this one, the Emergency Management Institute, EMI, through FEMA. That's the registration showing my classes through FEMA. It's a certificate of achievement is to the knowledge that Michael Paul has reaffirmed a dedication to serve in times of crisis through continued professional development and completion of an independent study course. And this course was effective communication. Issue date 7th June 2018 by Tony Russell, instructor. So that's the evidence of training. The evidence put forth in the affidavit, this is Exhibit 3, the IRS EIN issued by the IRS for showing the employer identification number, and it was issued the date of 4/19/2017. Then we go to Exhibit 4, included with 3 and 4. It's also an IRS document. This is the letter or certificate determining that we are exempt from federal income tax under the Internal Revenue Code, IRC, Section 501c3. Donors can deduct contributions made under the IRC Section 170. So qualified to receive tax-deductible bequests, devices, transfers, or gifts under Section 21055, 2106, and 2522. So it says this letter could help resolve questions on my exempt status. So keep it for my records. This was issued, the issue date on it was, effective date was back to May 3, 2017, which was our beginning unincorporated day that we began operating, May 3rd, 2017. So they backdated to the day that we first started. So we had continued 501c3 status since that time. Exhibit 5 was a request for the verification of my status as a public servant employed by a subdivision of a state, county, or municipality in my past, as required by the Community Emergency Response Team. This was signed by the board member. It was sent to California, to CAL FIRE. CAL FIRE responded with a notice from the Department of Forestry and Fire Prevention or Protection, Legal Services Unit, and it states, Mr. DeCino, we're providing a copy of Mr. Paul's work history with CAL FIRE in response to your recent request. And Hennigan, AGPA, CAL FIRE Legal Office, and that was dated June 22nd, 2017. Included the official printouts off of their computer database showing the position and time of reference for the employment. And last but not least is our Exhibit 7, which is the bylaws of the Emergency Response Team, which are our operational guidelines that we operate under. It's the laws, our bylaws. Contract makes law in this country, in this state, and in this country. So this is a contract. It's signed by all 3 board members, affirming that the document is in effect. So I believe I've sent you a copy of this, signed and dated by all 3 officers. And last but not least, after this document is included a unsworn declaration document straight from e-file at Texas.gov for declaring this document to be truth and factual as I know it to be under penalty of perjury. And it complies with CB-CHD 200 as the unsworn declaration. I don't know if I had mentioned the state tax exemption, but I have that also. Issued 5/3/2017, exempt from sales tax and use tax and franchise tax in the state of Texas. The application was submitted as a volunteer fire department when applying for the exemption. So the affidavit, prima facie evidence, stands on its own. I will be e-filing it into the court, just strictly because I haven't been called by Miss Molina. I've got calls in for her. I haven't heard from her. I would have preferred that I send it to her and she reviewed it and then she submitted it for me, but I don't think I'm going to have that luxury since it has to be filed by midnight. So, but it is what it is. So I'm on my way down to the FBI office, the field office, off of I-10. I've been there once before, back when I attempted to get my Social Security that was stolen by Greg Abbott, then Attorney General, who claimed I owed child support in excess of $11,000 when it was only ordered at $5,700. They collected $11,600 total that was confirmed by Social Security at an audit. And then when I had it stopped where they couldn't get any more, the Attorney General's office filed a judgment against me in the trial court, the divorce court, 225th District Court, claiming that they had a hearing and it was ordered against me that I be forfeited to the entire judgment amount, $5,700, as I never made any payments at all, even though they collected twice the amount. So that ended up in my credit bureau. When I went down to the courthouse to try to find the physical records, there were none. They were on the docket for the case file electronically. There was no physical records. Of course, I was never served any appearance notice under Rule 21 of the Texas Civil Practice Remedies that processes service. And so those were done through Ms. McKinney, who's the court clerk, filing fraudulent records into the court files. And that was part of my motion at the time when I came back to Bexar County and tried to get my money back, because Social Security told me they couldn't recover my money. I had to do it through the court system because it was taken as a forfeiture through garnishment, which the Attorney General, being the representative under Title 5 and 7 of the Federal Code through Health and Human Services, as the representative for federal government to collect the money through child support, has the ability to enter in judgments on the record without getting a judgment from a court, from a judge. And why they can do that, I don't know, but when they do it fraudulently, there's a problem. And of course, I didn't recover my money. The judge that I was going before was not the 225th District Court judge. They put me in another courtroom, and when I appeared, the Assistant Attorney General showed up and said that he didn't know anything about the case. He just gotten served that he just gotten given notice he's going to represent the state in it 24 hours before he appeared in court, which was a lie, because I met him in Comal County when I filed in small claims court, and the judge dismissed it at JP because she didn't have jurisdiction to hear the matter because it was out of a family court under the divorce. And anything in a family court has to go back through the family court. They're the only ones with jurisdiction in the case. So I went and refiled back in the family court. Ms. McKenna again took and changed the case number on my filing and scheduled it for a different courtroom. And I contacted the court clerk and informed them that if they didn't put it where it was supposed to be by law, because that's the only court with jurisdiction, that I was going to the Department of Justice and there would be an investigation done on Bexar County. So they did. They changed it back into the original case file. But when I went to court, it wasn't in front of the 225th judge. It was just another judge. And because the state got their continuance claiming that they didn't know about the case, can we come back in 2 weeks? He granted it, even though I told him that the attorney was lying. He knows me. He knows very well what this case is. The summary judgment motion was about, because I'm attempting to recover money that he had the case dismissed out of Comal County because it didn't have jurisdiction to hear the matter. So, but the judge went ahead and granted him his extension. When we went back in 2 weeks, the judge wasn't there, and a visiting judge from Austin was going to hear the matter and make a ruling. The only problem with that is like what's happened with Joey Contreras. Only a retired district judge, county judge, or an appointed judge, or an elected judge are allowed to take the bench in the state of Texas. Nobody else is. He was a retired comptroller for 35 years out of Austin. He worked in the tax office. He wasn't a judge. He had nothing to do with the judiciary, except processing their payments. So, but that day he shows up and he says that he has authorization, being retired comptroller, to sit on the bench. Me, not knowing what I know now, didn't question it. But I know now it was illegal. So when he dismissed my claim, and I appealed in the appellate court, Fourth Court of Appeals, Ms. McKinney again files a contest to my affidavit of indigency that the trial court had found me indigent in the original divorce. The Supreme Court had a miscellaneous order that stated anybody who is found to be indigent in a family court in the case remains indigent the entire case and any subsequent appeals in the case. But you see, they had a district judge order that I had to pay the costs on the appeal, and they sent that to the appellate court, and the appellate court gave me an order to pay the costs on the appeal, and if I didn't within 30 days, they were going to dismiss the appeal. Well, me getting my Social Security disability, I didn't have $250 extra that I could file in November around the holidays. No, I didn't have it. So of course I couldn't make it. But I sent them a motion telling them that the Supreme Court stated that I didn't have to pay it, and I should be considered indigent automatically because I was indigent in the trial court in a family law case. Well, the appellate court went ahead and dismissed it anyway on the 30th day when I didn't pay the $250 filing fee. So at that time, I had already realized that they were protecting the then elected governor. He was elected that November 2nd, and this was around the last week of November, first week of December when all this happened. So he was elected to office as a governor. I didn't know it at the time. I wasn't paying any attention to all that. So when it was dismissed and I saw what they did, I went down to the FBI office, the field office that I'm going to right now, and gave them every single document I had and explained to them what had happened, how my money was stolen, how they fraudulently filed documents, how they've dismissed my claims, and violated my constitutional right to due process. The FBI said, well, Mr. Paul, you honestly don't think the FBI is going to go arrest the brand new governor who just got elected in the state of Texas, do you? And I said, no, I don't suppose they will. And I was right, they didn't. But with what's happened with two judges, somebody in Austin sent both of them here. Okay? It just so happened that I'm in both those courts at the time. I believe in coincidence, but I also believe that beyond coincidence, because people make things happen. That's why things happen in our world. Not just because they happen. People make them happen. And when I found out that Contreras has not been confirmed, it was not confirmed by the Senate, and Governor Abbott, when session was out, had 10 days when session came back in November and December of 2017, to those 10 days to get confirmation of his appointment, didn't happen because no hearings were held until the next session of Congress in 2018, that Mr. Contreras took the bench without having been confirmed, which is a violation of the Constitution. And they knew it, had to have known it, because it's the law, it's required. There's other judges go confirmation, and they have to be confirmed before they take the bench. So you'll see in the hearing documents that are filed through the Senate online, that it shows the names in the courts of the appointments. There's appellate court appointments, there's district court appointments, and then there's employee appointments through the different subdivisions of the state government, commissions, and so forth. So, regents of colleges. The document I have is the printout from the nominations dated Monday, August 7th, 2017, which was the last hearing before Mr. Contreras took the bench in October. Judge Hilbig did not retire until September, so they'd already had the confirmation hearings for the first part of the Senate. This is a special session right here, okay, in August. This was a special session. It wasn't the first part of the year where they have regular sessions. This was a special session. So had he applied, like he said in an interview on radio that he did, Judge Contreras, that he applied for the position and that he was granted his application, approved to do it, he became the judge. But he never said he was confirmed. And anybody who goes through that process is going to be proud of it when they get confirmed, because it's really hard to get confirmed by a board of people who have to agree on everything, when it's hard enough to get 2 or 3 people to agree on anything. So the administrator for the Texas Bullion Depository that was formed to protect the gold supply for the state of Texas was appointed and nominated and was confirmed by the Senate. Also, the State Bar of Texas was Michael E. Dokupel. That's a tough one. Supreme Court of Texas nominee in Harris County, and Jared T. Forrester, Supreme Court of Texas nominee in Harris County. So they were both appointed on 5/30/17 for a term to expire 6/30/19. The first one, Dokupel, and then Forrester's was an extra year, but beyond that, 6/30/20. The nominations were done by Whitmire, Huffman, and Watson for all 3 individuals, and all 3 were appointed. Before the hearing, because the session was out at the time, and according to the Constitution, they have to be confirmed the first 10 days of session the next time Senate convenes. Now, that doesn't mean that they have to have the vote of all the senators. They have to be approved by the nominating committee that will be applied later to vote by the Senate majority. So the nice thing about the Senate Online is they got videos to all this. You can watch it happen in real time as it happened then. And all the documents are there. So it's all public record. And if it's not there, it's not there not because it's lack of competency in the public record. It's not there because it never happened. Now, I'll be honest with you. Judge Contreras took his oath of office October 23rd, 2017. Election was November 2018, November 2nd. The legislature, when they passed the Constitution requirements for the appointment, did have in there a waiver of having to have a nomination or having to be confirmed if you take your position on the bench and you're sworn in your oath of office is after November 2nd, the year preceding the general election. Anything less than that 1 year, you don't have to have it because the timeline's so short. There may be a session of Congress, but it's hard to get into it, whatever. Then they just figure, okay, so close to the election, we'll just forget the requirement and let the elections take their course. And you know, I can understand. I honestly believe they go, you know what, I'm not going to worry about it. 10 days from when he took his office and got on the bench to when statutorily he's required not to have been confirmed. 10 days. But it doesn't matter. It's one day. November 1st, he was required to have confirmation. And if he's not confirmed, he's to step down off the bench and another appointment is to take his place. The governor must make it. So, the fact that he remained on the bench and Abbott did not apply the first 10 days of the next session of Congress when they reconvened is a violation of the Constitution. Joey Contreras, impersonation of a public servant, is a judge. Should have known better. He's a federal prosecutor. And when he left, because he didn't win re-election, he didn't even win his primary. He didn't care. He went right back to being federal prosecutor. Hilbig retired all of a sudden. He's not supposed to retire unless he's 65, or no, unless he's 70. 70 to 75. Unless there's compelling reason for the Congress to let him out, to release him. Either he's got a medical issue, his spouse has a medical issue he has to take care of, or he's no longer got mental capacity to be a judge. Anything else, he's required to finish his term of service if he's under age 65, under age 70. 75, it's automatic. You leave early if you're 75 in that term. Okay. So the only thing I found from Hilbig was his Facebook page where he's in his office, in his chambers. It's April, May. He's talking about how cases are going, how he's liking his job. And no entries again until September when he says that he's decided to retire. He says, after 30 years of practicing law, it's time for me to take a break. He was 65 at the time. He just turned 65. He even says it on Facebook how old he is when they had a birthday party for him, which was the last entry before he decides to retire. So he can't retire at 65 early. He has to serve his full term if he wants to retire under the judicial retirement and get the benefits of the judiciary. Now, there is, like I said, there's compelling issues. If he had any of those things that were done, he has issues he has to deal with, and he can't deal with all of it and be a judge too. So he's handicapped. I understand that there's time that can happen. But first thing he didn't retire. He went into private practice, and he's practicing right now. He got his own office over there on De La Rosa Street, 100 De La Rosa. So he's working in the same field that he was retiring from. But why retire then? Why not finish your term? No reason was given. Medical reason, financial reason, problems with my grandchildren reason. Who knows? There's all kinds of things. Never does he say why, ever. No coverage on it. So, was it planned? Was it done on purpose? I can't say for sure. 100% for sure certain. No, I don't know. But, like I said, if it walks like a duck and it talks like a duck, it must be a duck. Unless it's impersonating being a duck. You know what I mean? Well, sir, I'm fed up with the harassments. I'm fed up with the lies, the cheats, the deceits. I'm done with it all. I had 10 years where I turned my life around and was doing the right thing, helping my community, doing the right thing for other people, making nothing on it for myself at all. Nothing whatsoever. Okay? for my government to do these things that have happened to me. They're documented. It's happened. It's not a feeling that it may have happened. It actually happened. You know? I was working at Lyft making $4,000 a month until it shows up as an arrest on my record that impersonation of public servant is a felony. So then I'm let go. I can't make an earning anymore. I'm making $4,000 a month. You know? And gone from me. Never to come back. A conviction as a felon that prevents me from voting in my election for my president, my representatives, my local officials. The removal of my Second Amendment right as a convicted felon. The seizure of my personal DNA taken from me the very minute after I'm convicted. I have to report to probation for a swab in my mouth for a DNA seizure. Okay? All of these things. My credit report's all messed up now. I can't get anybody to look at me for a job. Ain't no way. Not with 2 felony arrests on there and now it's showing 2 felony conviction. No. It ain't gonna happen. Nobody's gonna hire me. And I run the risk of losing my Social Security disability because they have a right to terminate it at will if I'm convicted of a felony. So, out of self-preservation and doing what's right, yes, sir, you will see me in my uniform tomorrow. And I will present myself in front of the judge, the 25th District Court, State of Texas, as what I am, sir. A volunteer first responder who volunteers times of emergencies and natural disasters, authorized to provide those services as a matter of right with my certification from subdivision of the state of Texas. Nobody can take that away from me unless I commit a crime. Now, no crime has been committed. When they claim that the crime that's committed is the impersonation of this office that I take right now and have been in legally. So, I'm not a conspiracy theorist. I don't go around finding conspiracies and everything left and right, and I'm that ill-minded to feel like everybody's out to get me. I know that's not true. But, like you said to me, somebody don't like me. Somebody's doing something and you just don't know what it is, but somebody's doing it. And if you could see that, and you're not a party to the case except for what we've discussed, then you're right. Somebody is doing something behind the scenes. And for whatever reason, they've decided that I'm the target. And it probably comes back to me trying to sue Greg Abbott in his official capacity to recover money that was taken from me that the state had no legal right to. They never gave it to my wife. I can't go after my wife to get it back, which is what they said happened. It's a bunch of crap. The state got it. It went into that fund, and they told me, they said, well, we can't pay you back because the money's not there. And I said, well, where's my money at? And she said, well, it's gone. And she said, but you can't expect us to take the money from somebody else and give it to you. And I'm thinking, oh, but it's okay if you take it from me and give it to somebody else. No, it's about the money. It's about money. It's always about money. It's crazy. Just downright insane. So, I'm going to go ahead and close off this video. I've got to get over to the field office of the FBI, and I've got to get there before 4:30. That way somebody will talk to me at least for a half hour. Otherwise, it does me no good. And I'll be unable to do it before attending court tomorrow. Just in case the judge does decide to put me back into jail, even though I will be appearing as I have agreed to. And that's the only reason that they're supposed to revoke that the bond. And another thing, why do I have 3 bonds now on my case instead of 1? When I'm only charged with 1 crime. I have 3 different bonds that have been issued for my case. Now, I know a little bit more than the rest, and I know about how they monetize these through the Federal Reserve, and they get a deposit credit to the county account for the amount of the bond. So yes, they do create bonds that are PR bonds, strictly so they can monetize them and get credit for the dollar amount through the Federal Reserve. And the Social Security Trust Fund accounts are real. I just charged a $3,500 Discover card that was paid. They gave me the paid receipts that they collected the money. Lowered my credit limit to $500 from $3,500 because I didn't make a payment in 6 months. Sent me a new card, and then 9 days later told me, no, we're wrong. We never collected that money, and I have to pay the original money. But now they're going to charge it off on my credit like I didn't pay anything, and that my credit limit was only $500. So now my credit score was dropped to 480 from 620 because I was 700% above and beyond my credit limit. I was so far extended on my credit that nobody was willing to give me credit for anything. I couldn't get a credit to save my life. I couldn't even get payday loans. That's how bad it was. So, yeah. But I digress. Alrighty, sir. Well, I'm going to be driving on the highway, and I need to pay attention. So that's all there is for this video. If you like, hit the like button and share.